CR 27-8, Jeffrey Furr. Is Jeffrey Furr here? Jeffrey Furr is not in the courtroom. I do not see him online either. CR 2261, Christopher Mata. Christopher Jean Mata. Kyle Holland. Record will reflect that Kyle Holland appears to be online. Stephen Flores. Thank you, Ms. Beasley. Donald Patterson. So he's not here. Zachary Duncan. Zachary Duncan. Could be an iPhone issue. We'll recall Mr. Duncan. Jamie Gant. Should be appearing. Zoom has not logged in. Yeah, there she is. Ms. Gant is present online. And so is Mr. Staub. Eric Rodriguez Castro. Eric Rodriguez Castro is online. Mr. Eastland's also appearing online. Wilbur Bear. Here. All right, Mr. Bear, your attorney, Mr. Files, is appearing online. We'll recall your case in just a moment. Devin Key. Thank you. Sean Kuntz. Sean Taylor Kuntz filed a waiver of arraignment. Pre-trial has been set on April 15th. Mr. Files, if you're still with me online, I would just ask that you let your client know that he needs to appear at the pretrial release office at the probation department and sign his conditions of pretrial release.
I passed that word to him already, Your Honor.
Thank you, Mr. Files. Sure do appreciate it.
Sure.
Quincy Hankins. Thank you, sir. Sadie Johnson or Say Johnson? Is it Sadie or Sade? Sade? Great, thank you. We'll recall that in just a moment. Melanie McQuarrie is present. Is Mr. Johnson here? Is your attorney here, Ms. McQuarrie? Michael Reisner. Megan Bailey. Megan Nicole Bailey.
Judge, I had checked this morning. She's going to be appearing. Or should be anyway.
don't see her logged in yet, so. Jimmy Gibson, Jimmy Douglas Gibson. Oh, verified that Mr. Gibson is in custody in Dallas County. We'll recall his case and schedule him. Thank you. Jose Vela. Devontae Wright. Mr. Wright is appearing online. Justin Reed. Waiver of arraignment filed and pretrial is set May 25th. Louise Leha is appearing online. Mr. Sminner is also online. James Gray. James Cody Gray. Motion for continuance. E-filed by Mr. Still. I believe the court has granted that and has set the motion to revoke on 3/23. And if the case is not resolved, will be set for a contested hearing on March 30th. Candace Smith. Thank you. Mary Dean. So I understand that Miss Dean may be running late. Elvin Barfield. Thanks, sir. Jacob Howell. Thanks, sir. Christian Pritchett. Janice Alcalon. Am I saying that correctly? Joshua Brown. Melba Kennedy. Thank you. Philip Smith. Kyle Connor. And let's see. Thank you, sir. Mr. Wood is already here. Chad Thomas. I do see, I do have a couple iPhones logged in, so it may be them. We'll have to check them after we call everyone else. We'll see when we get a break. All right, this is cause number CR 20-139-140, State versus Michael Edward Reisner. And we're set for docket call today, Mr. Platten. Mr. Platten, I was unaware of your medical issues until this morning. So I'm gonna go ahead and call your case and get you back. So we're set for docket call today, Mr. Platten. Do you have any announcements on docket call? You're on mute still.
Sorry, I thought I was off. Yeah, Your Honor, we're not ready at this time. As you can see, February was not a good month for anything. And I'm not mobile right now. I'm waiting to see how we're going to handle the situation that I'm in. Possibly having surgery here soon.
Okay, have we communicated the offer to Mr. Reisner and have we gone? I'm sorry, say that again.
I have not received an offer.
Has the state made an offer to Mr. Reisner at all?
I know that myself and Mr. Platten have been dealing with some discovery that will involve, I believe there's a control letter, but
Ms. Heisel still checking Mr. Platten.
Judge, there is an offer in the case. I will make sure that Mr. Platten has that today. He did not previously receive that.
What is the offer?
It's 20 on the indicting case, and there's also an indecency that was 1245 as part of our plea agreement.
All right, Mr. Patton. So there is an offer in the case, and the court's going to reset this for an additional docket call so that you'll have time to communicate that to your client. And let's, if you have your calendar available, Mr. Patton.
Okay, what month are you looking at?
April, today is the 11th. So are you available on April 15th? And I know
I
you
think so.
may not be aware, but legally speaking, on your legal calendar, are you available on April 15th? I know you may have medical issues that may,
It says tax day.
that is tax day. I was going to give you something good to think about.
I think I'm available that day. I do have another setting at 9:30, but, oh, that's a revocation. I'm not available that day. That's a revocation that morning.
Okay, are you in my court that day or another court?
Another court.
Okay. Do we need to, and we can bump it out a little bit later in the morning? You know, we could set it at 11 if you think that would help.
That would be helpful. We can see.
All right, Mr. Reisner, we're going to set you for a hearing on your docket call on Thursday, April 15th at 11 a.m. And on that date, what the court would like to hear is whether you accept that offer or the state's going to accept a counter offer. And if there's no resolution, then whether you want a bench trial or a jury trial. So Mr. Platten will be able to give you more information about that. Stay in contact with him and your bondsman. And once you sign that notice of setting, you're free to go. Mr. Platten, did you have another one that was on today's docket as well?
I don't think so.
Okay, I couldn't remember if there was.
Has two cases.
Say that again.
Mr. Riser has two cases that may be.
All right, we're gonna have him sign. You're free to go once you sign that notice of setting. Thank you, Mr. Platten. Hope you feel better. All right, counsel, in the courtroom, do we have anyone that's agreed or have a simple announcement? Yes. Okay. This is cause number CR 2109, State versus Kyle Stephen Connor. The state has tendered a motion to dismiss, and the court will grant that this day and has signing the order of dismissal. Can we check to see if Mr. Connor has paid any on his pretrial release towards attorney fees? He owes 100. How much do you know how much he's paid him? You can just check for him. All right. So what the court's going to do is have the pretrial release officer check to see how much attorney fee credit he has, and whatever he has is going to be applied towards the bill that's been submitted by Indigent Defense Counsel. So, Mr. Connor, you're free to go. Okay, give me just one moment. I'll call him. He hasn't paid anything? So he's what? Okay. All right, Mr. Connor paid no money towards pretrial release attorney fees, so county's going to foot that bill. All right, this is CR 2197, State versus Chad Thomas. And I do not see Mr. Thomas online unless he's this iPhone. Let's see. Is that your client that's going to be logging in here? Can you double click on his picture? Sir, is your name Chad Thomas?
Yes, sir.
Okay. All right, give me just one moment.
Yes,
Free trial, date in this particular case.
The prosecutor and I have been discussing Mr. Thomas's case. I received an offer yesterday.
And Mr. Wood, if you can, if you'll just right in front of that microphone, so because he won't be able to hear you unless you're in that microphone.
We're asking for another pretrial date in this particular matter. We've been discussing Mr. Thomas's case with the prosecutor. Received an offer yesterday, not been able at this point in time to get with Mr. Thomas to go over that offer and or go over the discovery in the case. I anticipate being able to do that relatively quickly. The offer was given to us yesterday, and so we're just asking for some additional time to see this through.
I show that we're set for docket call today, so let me look into that. I believe that we should already be past the pretrial and discovery stage, but let me make sure that it's not a mistake on the court's end. Let's see, we had two settings for arraignment. So it started back in September and we had arraignment September and then October. And then we had 3 pretrial settings, November, December, and January, and then 2 docket calls. I think both of those were reset. So this may be the first formal docket call. So what the court would be willing to do is grant an additional hearing on docket call, but not on pretrial.
State has no objection.
All right, are you available on April 15th, or is that the week that you're gone?
That's week.
I think we may have set you for the 27th. Okay, all right.
That'll be sufficient. If I can get something done before that, give the court try to set it up. The issue with this case was, I was under the impression that Mr. Thomas had hired an attorney. When in fact, I think there was some confusion on who had hired the attorney counsel who hadn't. So then I realized that I was still on the case. So now.
So Mr. Thomas hasn't hired independent counsel. All right. So Mr. Thomas, the court's going to order you to appear in court on April 20th at 9 a.m. for docket.
Yes, sir.
And on that date, then I'm wanting to hear whether or not there's going to be a resolution in the case, whether you accept an offer or the state accepts a counter offer. Okay.
Yes, sir.
All right. You're free to go. Thank you, sir.
Thank you, sir.
That's all I have this morning.
Afternoon.
I'll be on Zoom.
Yes, sir. See you then.
Thank you.
Mr. Head.
Yes, sir, Your Honor.
Mr. Hankins, if you'll make your way to the center podium, please. This is CR 2121, State versus Quincy, Lamar Hankins. I show that we're set for docket call today. Mr. Head.
Yes, sir, Your Honor. And I filed a motion to suppress back on January 28th, which I thought that's what we were set on today, but I guess I need to request an actual setting for that contested.
I show that we were set for evidentiary hearing on the 28th. Yeah, counsel, do you have any recollection as to why we didn't take up the motion to suppress at that time?
Yes, Your Honor. It is not, this is not working. It is not been served on the state, maybe it had been, there was a filing issue and notice, so we asked them to be set here for us to get proper notice. I need to really quick, Your Honor, the trooper schedule for the month of March. The state has now received that motion, and so we're ready to proceed. We can do it March the 30th, assuming that our witnesses will be available. If not, we will do it in April for the contested docket. I'll ask that those troopers be scheduled appropriately.
Do you have the trooper schedule with you today?
I do, so give me just a second, Your Honor.
Yes, ma'am.
Judge, I was staying for sit down on that docket. That's what I recall, that the state needs some time to actually review the motion and before we set the hearing.
Thank you, sir.
Judge, it appears that neither one of those troopers is in training, so I believe that we would be able to get some things on for the 30th.
That's fine with you, Mr. Head?
That's fine. That's great.
All right, court will set this case for evidentiary hearing on March 30th at 9 a.m. And Mr. Hankins, once you sign your notice of reset, you're free to go. You're welcome. Thank you, sir. Yes, thank you, Mr. Head. Mr. Weiner, Mr. White, y'all both ready?
Yes, I've got 3 of those. I got. Okay, I'm ready on all 3.
All right, Mr. Weiner, step on up. Yes, ma'am. Thank you. Elvin Barfield. All right, this is CR 2422, State versus Elvin Barfield. Mr. Barfield, will you raise your right hand? I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, nothing but the truth, so help you God? All right, you may put your hand down. You are Elvin Bascom Barfield, is that correct? And Mr. Weiner, it appears that Mr. Barfield wants to enter into the state's pretrial intervention contract program, is that correct? And it's for a charge of possession of controlled substance, 1 gram to 4 grams. And the period of the contract would be 12 months. Has Mr. Barfield prepaid his pretrial $500 fee?
Right now, I'm going directly to the DA's office.
And you're retained on this case, correct?
Only once, the city that agrees to allow us to probation office, my client to report every other month he lives in Florence, Louisiana. So that way he's not trying to come back every single month in our state.
And Judge, I would just slightly clarify that. It is my understanding he will be reporting every month. He would still have phone check in or Skype or Zoom, whatever probation requires, but it would only physically be present.
And y'all discussed that with the probation department?
Yes, Your Honor.
Okay. And you've explained to Mr. Barfield that by entering into this pretrial intervention contract, that there's certain rights that he's going to be waiving and giving up.
Yes, Your Honor. It's on the law.
Specifically, he understands that by waiving his right to a jury trial, that there's only very limited circumstances in which that could be restored to him.
Yes, Your Honor.
And you're joining him today in requesting the court to allow him to waive his right to a jury trial.
You are.
You've also explained to him that there is a limited waiver of his right of expunction with regards to his criminal records if he successfully completes this program.
Yes, I'm clear to thank the paper file will remain custody of the DA's office in Same County, but we did it for every other.
There's also a waiver of indictment in this case. Is that correct?
Yes. I can over his line to see that I agree to waive that.
And do you believe him to be competent today? All right, Mr. Barfield, do you understand that by entering into this program or entering into this contract rather, that you are giving up certain important rights, specifically your right to a jury trial? Do you understand that when you give up that right, you do not have the ability to cross-examine the state's evidence or their witnesses before a jury? And you understand that once you waive that, there's really only very limited circumstances that you could ever get that right back. And you're asking the court to allow you to waive that today. And you're doing that free will in accord, intentionally, knowingly, and voluntarily, meaning no one's put you under duress or coercion or forced you to make you feel like you had to waive your right to a jury trial. All right, the court will approve the waiver of jury trial. And you also heard Mr. Weiner inform the court that he's discussed with you that there's certain records that if you complete this program will not be expunged from your criminal arrest records. All right. And finally, Mr. Barfield, by waiving indictment in this case, you're allowing the state to proceed in your prosecution without having your case formally presented to the grand jury. Do you understand that? And you understand that all Texans who've been charged, all individuals in Texas who've been charged with a felony are required to have the case presented to the grand jury. The state's required to present that case to the grand jury to determine if there's sufficient evidence to go forward. But you, as an accused, have the right to waive that presentation to the grand jury and to proceed by information. And that's what you're wanting to do in this case. And if I asked you the same question before, no one's forced you, pressured you, made you feel like you had to waive your right to indictment. All right, the court will approve the waiver of jury trial, the waiver of indictment. Court will find that Mr. Barfield is intentionally, knowingly, and voluntarily entering into this pretrial intervention contract, and that he meets the requirements set forth in the contract. Mr. Barfield will be placed on the contract for a period of 12 months, and the court approves the stipulation of evidence that has been entered into by Mr. Barfield and counsel, Mr. Weiner. All right, Mr. Barfield, you can go ahead and step forward and come over to our probation department. They're going to give you additional information on the next step. We won't need a fingerprint on that one. All right, Mr. Howell. CR 2083, State versus Jacob David Howell. Show that we were set on a status for Mr. Howell's hospitalization. So he's out of the hospital now. Any updates?
He is good. I spoke to the state. My client still has some very sensitive damage from youth and still have to do the fuzzy removed. He has some memory loss issues, hearing issues. What I've spoken and would say is my opinion in agreement with it, but I'm going to give him some medical documentation as possible and see if we can try and resolve the case. So I'm not trying to delay, but obviously the first time I'm fine, they will be his opinion in our life-threatening situation in the hospital. I like the documentation and safety.
Correct, they're not setting for a hospital to provide that.
All right. Mr. Weiner, are you available on April 15th?
I have a setting, a fire setting 9 that morning, but I could get here before something. I might be a little late getting that.
Well, let's set Mr. Howell in for 11 a.m.
Okay.
on docket call
Yes, sir.
on April 15th. Mr. White, I'm going to take up a couple on Zoom that just have one case. Is that fine? Mr. Howell, once you sign that notice of setting and get the yellow copy, you're free to go. Mr. Files, are you ready?
Yes, Your Honor, we're unmuted and ready.
All right, and Mr. Bear, I'm sorry. Yeah, I'm going to do a couple real quick. Sorry. Mr. Bear, if you'll step up. This is CR 2322, State versus Wilbur Bear, and we're set for pre-trial today. Any announcements, Mr. Files?
Yes, Your Honor, we have no motions to present to the court. Ms. Curry and I have been in negotiations for some time on this. We are now on our second discussion of a resolution of the case. I met with Mr. Bear yesterday. He raised an interesting question of law that I simply did not have an answer to and need to look at. We would be ready next call of the court to let the court know where we're going to be, either trial or plea.
Are you available on April 15th?
We already have Coon set on the docket. I'd call the court's attention to one possible conflict I have. We are attorney of record for Ryan Nichols in the United States District Court of Washington, D.C. We expect to have a scheduling order out of that court next week. He is one of the January 6th defendants in that series of cases up there. I've talked to the opposing counsel. She does not believe we're going to have any trial settings up there that would interfere with that. That's the only thing that could possibly be a problem for me.
All right, we'll set Mr. Bear then for docket call on April 15th at 9 a.m. Mr. Bear, my staff's going to bring you a notice of setting. Once you sign that, you're going to get a notice of setting. Once you sign that and get the yellow copy, you'll be free to go. One more, Mr. Weiner, and then I'm going to get you back up, okay? Kevin D. I'm sorry, I got that backwards. Devin Key. I saw it, but my mind saw it backwards. CR 2292, Devin Key. And Mr. Files, any announcement on pretrial?
Yes, Your Honor, we do have an announcement. We have had an investigator working on our behalf for some time. We had an interim report this week of where he was. I would expect when he has completed his investigation, we will show the results to Ms. Curry, and I believe that that will be dispositive of our case. I cannot tell the court he's going to be through by April 15th, though I would hope so, and I'd ask the court to set it for that date with the possibility that we still have additional people to interview. We will try to be ready by April 15th for an announcement.
Yes, sir. Court sets Mr. Key then for docket call on April 15th. Mr. Key, once you sign this notice of setting and get your yellow copy, you'll be free to go. Okay?
Your Honor, that's all the business I have before the court. May I be excused?
Yes, thank you, Mr. Files.
Thank you, Your Honor.
You're welcome. All right, Mr. Weiner. Who do you want next? Pritchett or Alkaline? Oh, I'm sorry, that's Alkaline is Mr. Wise. Pritchett's your last one. I jumped the gun earlier. I thought you were done already. Christian Pritchett. This is CR 19153. This is a hearing on Mr. Pritchett's motion to revoke.
Yes, Your Honor, I've spoken with the state. We have an agreement to reset this case. The only non-technical violation that was filed in the motion to revoke by the state is a new offense, and that is an offense that has an offense report that Mr. Cox was trying to get back in the last year. And so we obviously need to have that before we do that. We're going to do the actual case.
Still don't have that offense report?
No, Your Honor, I thought that I had followed up on that, and I just looking back off the top of my head, don't see those notes. I will follow up in the meantime and see if we could, if not, the state will just prepare to move forward without that count.
I know Danny had, and I know Ms. Hess was called at least before trying to follow up. I know the state's been diligent trying to get it, so, and my client's out on law, obviously, so.
All right, court will set this for a contested hearing on April 29th. That should give enough time to determine whether you're going to get it or not and to prepare for a hearing.
And just my client has called probation. I know it's kind of strange times trying to record the scheduled time. I've been guessing with no avail. And so I've been instructed 10 after court to go to the probation department and say, I need to be able to report so we can continue to try and report and kind of make that relationship.
Once you're done here, just go ahead and have a seat over here and I'll have Ms. Burns, the Director of Probation, speak with you. Okay, she'll give you additional information. Mr. White,
Yes, sir.
are you ready on Janice Alkaline?
I am.
Ms. Alkaline, CR 2376. I believe that we're set for pretrial today, Mr. White.
Yes, sir. Got a couple of issues here. I got the state provided me with a flash drive. And there was an interview on that flash drive that I could not get to come up. I believe there also may be a cat, called Mr. Woodwhack, on that. So I'm gonna need to I'm gonna need another pre-drive. That's what I'm getting at.
All right, you available on the 15th?
Sure, I will be.
All right, court sets Ms. Alkaland then for pretrial again on April 15th at 9 a.m.
And Your Honor, I filed a motion to transfer a couple of misdemeanors up here. I don't know if that's come across yet.
I believe I've seen them on the Alkaland that we've seen them on. I believe that we've seen them. They were not, there was no transfer procedure brought to our attention. So just inadvertently through your announcements, we've had to go look for them. So I believe that we have them now. In the last couple of days, I've signed orders. So hopefully that's in the process. If they have been ordered, then just call my attention to it. If I don't, bring it up next time and we'll put them all on the same docket.
Judge, just for the record, we were running Mr. White, our chief cat videos in our office, our office, also need to come to our office. Yes, there are.
Joshua Brown. CR 2379, set for pretrial.
Your Honor, I filed a motion for some discovery on some blood evidence on Mr. Brown's case. I discussed that briefly with Mr. Woodwhack. This is a motion I filed before. They'll just have to contact the lab and tell them that we need it and come with this. I don't know more about how long it takes to get anything from the lab. No, it's the blood. It's
Judge, that can take about a month, maybe a month and a half, at a time, to get in contact with the lab, get the discovery, because you want to request it. We will make sure that that is in process, but we can't promise, of course, we'll have to out of order.
All right, court will set this for a status on the blood lab discovery on April 15th at 9 a.m. While he's doing that, Ms. Beasley, how many clients do you have ready?
I have, clients on the docket, one hasn't shown yet, Judge, I have this report, present on the budget.
Okay. What about you, Mr. Sanders?
I have 4.
Are they all ready?
Judge, I would also know Mr. Littlemore, he has one.
It's a plea, yes. I have my pleas back here. So I'm just going to try to move out the people before we bog down in a plea real quick.
Okay.
Melba Kennedy, CR 1959, CR 20171, CR 20257. Show that we're set for everything. Motion to adjudicate, pretrial, and an arraignment.
Traffic. Your Honor, as far as the new case goes, the state contacted me, said it was contacting me. I think Monday said that they had the video agreement on that. So I just asked the court to carry them over to pretrial.
All right, have you reviewed the indictment with Ms. Kennedy and the possession of controlled substance, penalty group 1, less than 1 gram, state jail felony, the new charge, CR 2257?
I don't believe that we had to get ourselves turned in on that case. And I have not seen the indictment, which is obviously sealed.
Do you want to bring Ms. Kennedy around to the screen and speak with her privately? Yeah, and if you want to, you can pull that TV out, Mr. White, and it'll tilt.
That's what we like, what you're on. Your Honor, we know what we're charged with. That's Ms. Kennedy's name. She spelled correctly in that. At this time, we'll enter a plea of not guilty.
All right, court will set each case for hearing on April 15th. Pretrial on the non-probation cases and hearing on the MTA, MTR on April 15th at 9 p.m. 9 a.m. Sorry. Pretrial. All right, Ms. Kennedy, you're free to go. Philip Allen Smith. This is CR 2411 set for pretrial.
Your Honor, I filed a motion to suppress on this, but I talked to Mr. Woodblack. Rather than setting this for an evidentiary hearing right now, if we could reset this for April 15th, I think there's a chance that we might resolve it in that day.
All right, court will set this for, I'm just going to call it docket call, Mr. White. And then if there's a need to re-urge your motion to suppress, I'll let you do that.
Yes, sir.
We'll set that for 9 a.m. Oh, you have, Mr. White?
I believe so, Your Honor.
Thank you. Yes, sir. Thank you.
Thank you.
Yes, sir. Let me mute this for you. CR 2211, Stephen Flores. Mr. Flores, if you'll make your way to the center podium, please. All right, Ms. Beasley, Mr. Flores is set for docket call today.
Yes, sir, I asked for an additional docket setting. Mr. Flores was in the hospital previously, 6 days, so 1 stay. He did go through several medical tests, scope of the upper portion of his body, but it didn't find the location where he was bleeding from. He had some major bleeding, I still don't know where that source is coming from. And the doctors have recommended that he do a another scope on the lower portion of his body. It tentatively is scheduled for the 29th of the end of this month, but he has to have $1,000 to be able to pay that, and he's waiting on his IRS check to come back. So we're hoping that he can get it done by the next setting, but if he doesn't get his IRS check back, we'll have to schedule it a different time.
That's all. So that's all in relation to his medical issues.
Yes.
What about his legal issues? What's the announcement on offer, acceptance, rejection?
We got the offer. We're planning on doing the plea. It's the same amount of prison time, and they need this test done and surgery done before we can do the plea.
Judge, that's correct. I believe we have an agreement, like she said, for prison time, but obviously, Mr. Flores needs to figure out internal pleading before, going into the custody of the state of Texas. Within reason, we have no objection in passing this another month to find out the status of that.
So do we feel confident that there's going to be a plea in this case?
Yes, sir.
Do we want to discuss waiver of jury trial today? That would make the court feel better rather than just resetting him, waiting to see if he's ever going to get to a point where he can physically accept an agreement or not. This way he doesn't end on my jury docket. Yes, ma'am. Yes, ma'am. And let me mute you. Yeah, go ahead. Go ahead. Mr. Sanders. Who are you ready on? And
Just we can do, look at bailiffs here, and we've got three waivers on just two cases. And then, Devontae Wright and Megan Bailey, should be on Zoom.
okay. Megan Bailey. Yes, I do see her on Zoom. Okay. Are you ready, Ms. Beasley?
Yes, sir. We'll sign that waiver, it's for, then I will with the contract out.
Okay. So Mr. Flores, just have a seat and we'll recall you again in just a moment. And Ms. Beasley, while I've got you there, so let me mute this. Mr. Sanders, I'm ready. Who's here in the courtroom with you?
Jose Bailey
Mr. Vela?
and Judge Iker.
Yes, thank you. Reading my mind, Mr. Sanders. This is State versus Jose Luis Vela, CR 2143 and CR 2273. We are set for docket call today. Any announcements, Mr. Sanders?
Yes, we have reached a plea agreement in these two cases, and we're executing three waivers today, and would ask if we could reset both cases for plea. If we do it in a couple of weeks, on the 25th, that would work.
All right, the court will set Mr. Vela for a plea on March 25th. And do you have any conflicts at all that day?
No, actually, I'll be over here. In fact, it's for prison sentence, so we want to set it for 1:30.
Thank you. Yes, let's set it for 1:30. So Mr. Vela, you will appear at the Van Zandt County Justice Center in the afternoon on March 25th. All right, and we'll do your plea over there and you'll go into custody that day. A couple questions I have for you, Mr. Vela. If you'll raise your right hand. Sir, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God? All right, Mr. Vela, you can put your hand down. You are Jose Luis Vela, correct? Mr. Vela, I hold in my hand two documents entitled Waiver of Jury Trial in each one of your cases. In this document, it tells me that you've been advised that you have the right under the United States and Texas constitutions to have your case tried before a jury of your peers, and that you understand that you have the right to subpoena witnesses, to cross-examine the state's witnesses and their evidence, all in front of that jury. You understand that, correct? You also understand that you have the right to waive that very important right of trial by jury. Are you waiving your right to jury trial today because that's what you want to do? Has anyone threatened you, forced you, or pressured you to waive your right to a jury trial? All right. And Mr. Sanders, I see that you and the state have both joined in with Mr. Vela in requesting this waiver. Is that correct? All right. Court approves the waiver of jury trial, finds that it has been entered knowingly, intentionally, and voluntarily. Court has set Mr. Vela then to appear on March 25th at 1:30. All right, Mr. Vela, once you get your notice of setting, that yellow copy, you'll be free to go. All right, so I see Devontae Wright is online, and what about Jimmy Gibson?
Just he's in the Dallas County.
You know, I keep on, can't, obviously I'm colorblind. I can't read red font, you know, the red that stands out on the highest end of the frequency. All right, let's go ahead and take him up. CR 1793, State versus Jimmy Douglas Gibson. And we were set today for his Dallas County custody status, and we've confirmed that he is in the Case Tower in Dallas County. So let's reset him for another status on the, I don't want to set it on the 25th. Let's set it out a little further. Do you have any settings that you're coming back for in April already?
I believe April 15th.
15th? All right, well, let's set him for that same custody status. We'll set that for 9 a.m. All right, I'm going to attempt to bring in Miss Bailey and also Mr. Wright. We'll see who's on first. All right, Miss Bailey, I'm going to ask you.
I'm sorry, sir.
I'm going to ask you to unmute your device. All
Can
right.
you hear me now?
Yes, I can hear you. This is CR 2378, State versus Megan Nicole Bailey, and we're set for pretrial today.
And Judge, we don't have any pretrial issues. We have the discovery, and ask go ahead and set this for not call.
All right, court will set Miss Bailey to appear before the court in person for docket call on April 15th at 9 a.m. So Miss Bailey, you're going to be ordered to appear before the court in person on that date. Do you understand?
Yes, sir.
All right, this will be the only notice that you get. Make sure you stay in contact with your attorney and your bondsman, and you're free to go.
Thank you, sir.
You're welcome. All right, Mr. Wright, I'm going to ask that you unmute your device and get it real still for me. Maybe set it down so it's not so bouncy.
Yes, sir.
Thank you, Mr. Wright. Appreciate that. This is CR 18344, State versus Devontae Trayvon Wright, and we're set for pretrial, Mr. Sanders.
Yeah, yes, sir. And we don't have any pretrial issues. If we can set for not on April 15th, should be able to do that.
You're anticipating a plea on that? All right, court sets Mr. Wright to appear in person on April 15th at 9 a.m. Mr. Wright, you understand this will be the only notice you receive from the court?
Yes, sir.
All right, we'll see you on April 15th at 9 a.m., sir.
April 15th, 9 a.m.
Yes, sir.
All right.
All right, we'll see you then.
Yes, sir. Thank you.
All right, you're welcome. You're free to go. All right, Ms. Beasley, are you ready? Yes, ma'am, please. Mr. Nicholas, has Miss Dean arrived yet? All right, Mr. Flores, if you'll step back up, please, sir. All right, Mr. Flores, if you'll raise your right hand. Mr. Flores, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you can put your hand down. All right, you are Stephen Flores, correct? Mr. Flores, have you discussed your right to a jury trial with your attorney, Ms. Beasley? You understand that that's a very important right that's guaranteed to you by the United States and Texas constitutions. You understand that that right cannot be taken away from you, but you may waive that right. You understand that by waiving the right, you're also waiving the right to cross-examine and confront the state's witnesses and their evidence before a jury. You understand that by waiving that right, there's limited circumstances in which that right could be restored to you. Has anyone threatened you, forced you, or pressured you to waive your right to a jury trial in this case? And you're doing so of your own free will and accord. And you're asking the court to waive it today, is that correct? All right, the court finds that Mr. Flores's request to waive his jury trial has been entered into intentionally, knowingly, and voluntarily, and he is joined by counsel, Ms. Beasley, and also the attorney for the state. Court hereby approves the waiver of jury trial in this case. All right, so as to scheduling, all right, tell me again, Ms. Beasley, what you propose.
Your Honor, I would propose that with the first commission, we go to an April the 15th setting to find out if he's been able to get his IRS check, get that test done, if not, allow us to do the setting.
Okay, so we'll entitle that status on plea,
Yes, sir.
and we'll set that April 15th, and you're available in the morning?
Yes, Your Honor.
We'll set that at 9 a.m. then.
Yes, sir.
And although this may be, although this may be a little, I don't want to say premature or, we got conditions of pretrial release we need to sign. Do we want to go forward with that since we're anticipating a plea? All right. So I want you to go ahead and report to Ms. Burns over here. Whenever you get done signing your notice of setting, you'll get that yellow copy. Just come see Ms. Burns and she's going to have some paperwork for you to sign. There's going to be conditions of pretrial release associated with your bail in this case. And you're going to have to report, you're going to have to drug test, and we're going to supervise you during that time. Okay. You're going to have to make payments towards your court-appointed attorney. And so regardless of whether you plea or not, we're going to go ahead and do that. So that's what I was trying to indicate. Whether you plea or not on April 15th, we're going to go ahead and sign them up. So you may not do a whole lot on pretrial release between now and then, but just kind of as a safeguard, we're going to go ahead and do that. Okay. Oh, he's already signed them? All right. So you have a copy of your pretrial release conditions? Okay. All right. Then you're free to go. We'll see you back on April 15th.
Thank you, Your
All
Honor.
right. Yes. Thank you, Ms. Beasley. All right. Mr. Lenore? Yes, please. I appreciate your patience. All right, this is cause number CR 2394, State versus, you said Sade Simone Johnson. And Ms. Johnson, will you raise your right hand? I'm going to place you under oath. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you may put your hand down. Ms. Johnson, are you a United States citizen? Do you read, write, and speak English? Have you ever been diagnosed with any type of mental condition? And go ahead and speak up a little louder so my court reporter here can hear you.
Yes, sir.
You're a little bit soft-spoken, and that's okay. And in this case, you are represented by your attorney, Mr. Martin Lenore. Are you pleased with his representation of you?
Yes, sir.
And have you feel like you've had enough time to talk to him about your case and have all of your legal questions answered?
Yes, sir.
Is there anything about the paperwork that you signed today that you do not understand?
No.
All right, Mr. Lenore, do you believe your client to be competent today?
She is competent.
And you've explained to her her legal and constitutional rights?
I have no.
It appears that there's a plea agreement in this case, and Ms. Johnson was previously indicted with the state jail felony offense of possession of marijuana, 4 ounces to 5 pounds. But it appears to the court that the plea agreement in this case is that Ms. Johnson's going to enter a plea of guilty to a lesser included charge of possession of marijuana, 2 ounces to 4 ounces, a Class A misdemeanor. And the recommendation appears to be, upon that plea of guilt, that punishment be assessed at 2 days confinement in the county jail with credit for time already served, a fine of $2,195, $180 restitution, and the state's going to dismiss under Section 1245, DA 2020-666, a possession of controlled substance, penalty group 1, 1 gram to 4 grams. In addition, there's reimbursement fees of $35 and court costs of $270. Is that your understanding of the plea agreement? It says 1245.
Just for the court's information, she was arrested for possession of controlled substance. Mr. Lenore and Ms. Johnson turned over to the state that she did in fact have a valid prescription for the medication. We are taking into consideration. It is not indicted or charged. We are taking into consideration.
So the DA's office is going to reject it.
Yes.
Okay. Thank you for that clarification. I appreciate that. All right. And so, Ms. Johnson, you heard me recite what the plea agreement is. Are all those things what you understood to be happening today in court?
Yes, Your Honor.
All right. So, Ms. Johnson, the range of punishment for a Class A misdemeanor is confinement in the county jail up to 365 days and a fine not to exceed $4,000. Do you understand that full range of punishment?
Yes, Your Honor.
And it appears that the plea agreement in this case would fit well within that range of punishment. So at this time, Ms. Johnson, I'm going to ask you, how do you plead to the Class A misdemeanor offense of possession of marijuana greater than 2 ounces, but less than or equal to 4 ounces? And Ms. Johnson, are you pleading guilty to that offense because you are guilty of that offense?
Yes, Your Honor.
Has anyone threatened you, forced you, or pressured you to plead guilty to this offense?
Yes, sir.
All right, the court accepts the defendant's plea of guilt. Mr. Lenore, any objection to the admission of States 1, the stipulation of evidence?
No, Your Honor.
All right, States 1 is admitted into evidence and the court takes judicial notice of Ms. Johnson's judicial confession. Is there anything further from the state?
No, Your Honor.
From the-
Just that we would be taking into consideration rejecting that unfiled case.
From the defense?
Yes, we don't have anything for, we're gonna, she's gonna pay the fine.
Oh, she is? Okay, good. Excellent. Thank you for that. All right, I'm just take a moment to briefly review the evidence. And Ms. Johnson, throughout these documents, I see your signature. Would you tell me that that is your true and correct signature on these documents? I don't know if maybe if I hold it up there.
Yes, Your Honor.
Is that your true and correct signature? And you've only signed these documents once you have understood everything that you were reading, correct? State, I don't believe I have any evidence to support the plea. I don't see an offense report or an information or the indictment. Mr. Lenore, do you still have that?
Yeah, it was attached to, Your Honor, I have, my copy that I printed off of the offense.
I'd like to review it, but I'm going to need to keep it and put it in the record as well.
Judge, I can try to get, I can make another copy, or I can give you my computer so you can read the offense.
If you'll just give it to my staff, she'll go make a copy because I'd like for it to go ahead and go into the record and in the clerk's record.
Judge, if you like, I can give you a summary and pass.
Yes, if you want to do that. Yeah, let's go ahead and do that.
On 7/16/2020, Trooper Joseph Sangbee, Texas Department of Public Safety, made a traffic stop on a Graveport focus that was driven by the defendant for speeding over limit 91 and 75. he detected an odor of marijuana. Mr. Johnson stated that she had a broken set of consoles, which probably caused surge, when which he located some marijuana. There was also located a glass mason jar in the trunk with some bags of green leaf-like substance later revealed to be marijuana. And Ms. Johnson was placed under arrest at that time. And then the lab has it's marijuana. I think the lab originally came back to being about 6 ounces, so just over 4 ounces. And in negotiations with Ms. Silicone here, we proceeded with lesser.
Any objection to that summary?
No.
All right, then based on the evidence presented to the court will find that there's sufficient evidence to convict Ms. Johnson of this Class A misdemeanor offense of possession of marijuana. Thank you. Greater than 2 ounces, but less than or equal to 4 ounces. Court hereby assesses her punishment, convicts her of that offense, and assesses her punishment at 2 days confinement in the Van Zandt County Jail. Court awards Ms. Johnson 2 days credit for time already served in this matter. Court assesses a fine of $2,195, orders her to pay $180 restitution, $270 court cost, and $35 reimbursement fee. And the court will note that the DA's office has agreed to reject DA 2020-666, possession of controlled substance in penalty group 1 gram to 4 grams. Ms. Johnson, you're hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of the sentence. I'm going to have you step forward to be fingerprinted here with my bailiff, and then you'll be free to go. And if you would step across the hall and discharge the financial obligations, then I'd certainly appreciate it. Is that all you have this morning? Is that all you have this morning?
I didn't know. First time I'm getting this court, all the time. I was doing that earlier. I tried jury trial. Oh, the last time I was here.
It's been a bit, hasn't it?
No,
Well, good to have you back. All right, thank you, Ms. Johnson. You're free to go.
John.
All right, Mr. Eastland, are you ready?
I am, Your Honor. Took me a while to hit the unmute button.
Here, you're a little one-armed today, is that correct?
Yeah, I had a carpal tunnel release Tuesday afternoon
Well, I
to
hope
match
that's
this one.
to match that one. Nice. Well, so there's a bright side coming soon, right? Is that right?
No, I've already done the right side. The left side was last Tuesday. So I should be good to go in about a week or so.
Yeah, no, I said the bright side. There's a bright side coming to your surgery, meaning that it's going to be like your right side. Are you ready, sir?
That's true.
Are you ready on Rodriguez Castro?
We are essentially ready on our part. I'm still waiting for the intoxilizer discovery from Ms. Heisel.
Okay, let's do this. Let me bring him in and we'll make that announcement. Give him just a moment to connect. All right, Mr. Castro, I'm going to prompt you to unmute. All right, this is cause number CR 2358, State versus Eric Gerardo Rodriguez Castro, and we're set for docket call today. Mr. Eastland, go ahead. Mr. Eastland, can you not hear me?
It breaks up every once in a while, but I can hear you.
All right, can you go ahead and give me your announcement on docket call now that Mr. Castro is with us?
Okay, we are ready for trial whenever Ms. Heisel gets us the intoxilizer discovery.
And Judge, the state does have that. I am in the process of trying to redact it. It's about 140 pages, and there's 2 pieces of information on every single page that needs to be redacted before we can turn that over. It is in compliance otherwise with Mr. Eastland's pretrial motion. I do have it. I will hopefully get it to him by end of next week, the latest.
What are you having to redact? Not just the type of information?
It's names and date of births of people other than this defendant.
Did you hear that, Mr. Eastland? Mr. Eastland, did you hear Ms. Heisel?
I did not hear all of that, Your Honor.
In summary, she says she has the evidence that you are needing. However, it's about 140 pages and she's still in the redaction process that she needs to complete before she turns that over. So I guess my question now. Go ahead.
I'm sorry, redaction of the intoxilizer records?
Yeah, yes, sir. There's other individuals' information that are not your client that need to be redacted.
Well, I need to see those reports to see if there are any failings. I don't care about the names or identification. Technically, those are public records, and
I understand. Ms. Heisel says she's going to redact the names and date of births of other individuals only.
okay. I don't care about the names. She can redact the names, but I still need to see the information.
Yeah, she's just going to.
Will be available just on the names and date of birth of the other defendants. That is what we will be redacting from the record.
Did you hear that? She's just going to redact.
If that's all, that's fine.
Okay. All right.
Because I don't care about names. I don't care about birth dates. I just want to see the information.
All right. So the court can then accept that this is a request for a jury trial. Is that correct?
That's correct, Your Honor.
Okay. All right. So we'll place Mr. Rodriguez Castro on the court's jury selection docket beginning on April 5th. So Mr. Castro, the court's going to order you to appear in person at the Van Zandt County Courthouse on Monday, April 5th for jury selection. Your case will not be reached for trial on that date. However, the court will have staff who will issue you a new date for you to appear, and they'll give you further instructions. So you're going to appear at every jury selection docket until your case is reached. Mr. Eastland will not be here on that date unless he so chooses. Rather, he will not be required to be in court until he receives notification from the court that his case, your case, could be in the top 10 for trial. Do you understand that?
Yes, sir.
Okay. So on April 5th, you'll report at 8:30 in the basement of the Van Zandt County Courthouse, and Ms. Taberham will give you more information on that date. Okay?
Yes, sir.
All right. I want you to stay in contact with Mr. Eastland and your bondsman, and you are free to go.
Thank you.
Is that all, Mr. Eastland?
Your Honor, I did not hear all of that, but I'll talk with Patty later on.
Okay.
Okay. Thank you.
You're welcome. You're free to go. All right, Mr. Sminner, I believe I see your client. Let's see here.
Yes, sir. Luis Leja. He should be online there somewhere. I'm
Yes.
texting with him right now, as a matter of fact. There he is. Is that him? Yeah.
Yes, he's connecting to audio. Let's give him just a moment.
Okay.
All right. This is cause number CR 17204, Luis Leja. I show that we're set for hearing on the motion to revoke today.
Yes, sir. Ms. Curry and I have been in communication, and since the last setting, what we're looking to do is reinstate him, but she wants him to get some things done before then. Since the last setting, he was required to make a payment. He made a payment of $1,600 towards his court costs and fines. And yesterday she mentioned in an email that we need some additional time. She wants him to be reporting back to his probation officer and getting some things done before she actually reinstates him. So she suggested that we ask for perhaps 90 days, if you could give us that, to give him time to get some additional things done.
I can confirm that, Your Honor. It was Ms. Curry's recommendation.
I can't hear her.
Can you just, step up to the podium?
That we do a 90-day reset. It was Ms. Curry's recommendation for that. I believe Mr. Layhawk still has some things to prove to the state of Texas before we're comfortable with outright reinstatement. In those 90 days, we'll give him the opportunity to show that that's a responsibility.
Is Mr. Leja still reporting on community supervision?
Well, actually, he has an appointment for the 22nd. And Your Honor, I'm sorry, I didn't hear what she said. Could you summarize what she said?
I'm gonna let her try again. Well, this microphone or those microphones are the ones that tie directly in. I think this is just a.
Mr. Senator, can you hear me?
No, I just barely make out your voice.
Okay.
Yeah, come on closer and let's see.
Mr. Senator, I just said that I can confirm that it was Ms. Curry's idea to do the 90-day extension for Mr. Layhawk to prove himself to the state of Texas that reinstatement is going to be successful course of action.
Yes. Okay, thank you. Yes, that's correct. He has an appointment to report on the 22nd of this month. And so that's what we need to do.
All right, Mr. Spinner, are you available on either June 15th or 17th? That would be right there in that 90-day mark that you're asking for, that the state's in agreement with.
Yes, sir, either day.
All right, let's set you for June 15th. So Mr. Leja, you're going to report to the probation department on the 22nd with your already, previously scheduled appointment. And then you're to continue reporting as directed. And we'll see you in court in person on June 15th at 9 a.m. You understand that? And I'm gonna have you unmute here. I'm gonna prompt you to unmute. All right, Mr. Leja, did you hear the court's instructions that you'll appear before the court on June 15th at 9 a.m.?
Yes, sir.
All right. Okay. You're free to go. Stay in contact with your attorney and your bondsman.
All right, thank you.
All right. Is that all you have, Mr. Sminner?
Yes, sir, it is. Thank you, sir.
Thank you. Free to go. All right, Mr. Staub.
Good morning, Your Honor.
Good morning. I don't see your client.
They're both on there. Their husband and wife, Zach Duncan and Gant. They should be on the iPhone I'm talking with them.
Okay. I see Gant. Okay.
So they're together.
Okay.
I believe it's a pretrial setting, a first setting, Your Honor, and I would just like some more time so I can download.
Yeah, I understand. Let me bring them in. Hear
Okay.
your announcement. That way they can see you earning your money. All right, the court's going to call these cases at the same time. This is CR 2384, State versus Zachary Perry Duncan, and also CR 2386, State versus Jamie Halise Gant. And I show that we are set for pretrial in each one of these cases. Go ahead, Mr. Staub.
Yes, Your Honor, we are here. It is a first setting. We would ask for another reset for time to download and receive discovery. And then we are trying to gather some information to work with the ADA to hopefully resolve this case sooner than later, or cases, I should say.
Okay, so you don't have discovery yet?
I'm in the process of downloading it. To be honest, I've not worked in your court, and so I'm going through that process of getting signed up and all of that.
Any objection from the state?
No, Your Honor.
All right, Mr. Staub, are you available on April 15th?
I am not. I have a federal court in the Northern District of Texas starting April 5th. That will be a 2 or 3 week trial. Can we do late April?
Did you say starting when?
April 5th.
Starting April 5th.
USA versus Jonathan Davis.
What about April 27th?
That should be fine.
Okay, so Mr. Duncan and Ms. Gant, the court's going to order you to appear in person. Well, let's see, you live in Louisiana, I see here.
Correct.
All right, so what we're going to do is I will set this for pretrial again on April 27th at 9 a.m. And I will allow you, Mr. Duncan, and you, Ms. Gant, to appear again via Zoom. And so, Mr. Staub, the court coordinator can provide you with the new Zoom ID to provide to your clients. And if your clients can't get a hold of you, then they're always welcome to call the court and we can give that Zoom ID. Okay, so I'm going to prompt you to unmute Ms. Gant and Mr. Duncan. Can you just push that button for me? Okay, so did each one of you hear the announcement of the court that you're due back on April 27th in person? I'm sorry, via Zoom?
Yes, sir. Yes, sir. Yes.
All right. And so your attorney will have that Zoom ID number, and if he's in trial or you can't get a hold of him, you can always contact the court and we'll give it to you. Okay?
Yes, sir.
All right. So I want you to stay in contact with your bondsman and your attorney. And Miss, hang on just one second. Okay. All right. So you're free to go. We'll see you back via Zoom on the 27th.
Thank you, Your Honor.
All right.
All right.
Yes,
Thank you,
sir.
Mr.
Thank
Staub.
you.
You're welcome. Have a good day.
Thank you. Thank you. You too.
Hey, Judge, can you hear me?
Yes, sir. I can, Mr. Harper. How are you today?
Doing very well.
Appreciate your patience. I had a crowded courtroom this morning, so taking my time to try to get them moved out. So this is cause number CR 2291, State versus Kyle James Holland, and we're set for pretrial today, Mr. Harper. Are there any contested pretrial motions, motion to suppress, motion to quash, anything of that nature?
There is not, Judge.
Okay. Are you ready to move forward then just to a docket call announcement to give yourself some time to continue to negotiate with the state to see if y'all can reach a resolution?
Yes, sir. I've reached out to Tyler a couple times. We've missed each other, but I have all the discovery now that I need, and I've had consulting, with Mr. Holland. I'm at that point. I think we have a conversation. Hopefully, we can work out a deal that works for everybody.
Okay. Are you available on April 15th?
It's tax day.
Ooh. I'll give you an order if you want. It says you don't have to pay taxes that day because you have in court, I can do that for you. I don't think they're going to honor it, but I can do it.
They won't. You know what? I like the sentiment, though. We're on the same side. Is that your docket day of the week? I am set in Collin County, but what time is your docket that day?
Well, we can do later that day if we need to. Well, we do jail in the afternoon and we do all clients that are on bail in the morning. What about April 13th? Would that be a better day?
If it's for a live appearance, Judge, or a Zoom?
Well, for counsel, I will allow Zoom appearance, but for
13th would be perfect.
Mr. Holland, I would do in person.
Yes, sir. 13th would be perfect.
Okay, so let's do that. We'll set Mr. Holland then to appear before the court for docket call on April 13th. So Mr. Holland, you'll appear in person, and Mr. Harper, if you need to appear at Zoom, you can do that.
Thank you so much, Judge. That we'll be able to take care of it. And I appreciate your help.
You're very welcome. All right, so Mr. Holland, stay in contact with your bondsman, and Mr. Harper, and you're free to go. We'll see you back on April 13th in person.
Thank you, Judge. And I'll get instructions from your coordinator. Well,
for Zoom?
Yes, sir.
Yes,
Should
yeah,
I
reach out to her and she can give you that Zoom ID.
Yes, sir. Thank you, Judge.
You're very welcome. You gentlemen have a good day.
Okay, goodbye.
Mr. Stevens, I'll be with you in just a moment. Be just a moment. Ms. Smith, Candace Smith. Sorry, Mr. Stevens, I had some issues on my docket that I was trying to figure out.
Hey, no problem.
This is cause number CR 2368, State versus Candace Kalen Smith. Ms. Smith, can you see Mr. Stevens in this monitor down here at all? Let me try this. Can you, how about now? I tell you what, give me just a moment and we need to recast you to the courtroom because I want your client to be able to see you, mister.
Yes, sir. Yes, sir.
Can you double click on his picture?
Yeah. It's just a.
All right. All right. Just give me one moment, Ms. Smith, okay? All right, Mr. Stevens.
Yes, sir.
All right, this is CR 2368, State versus Candace Keelan Smith, and we are set for pre-trial today. Go ahead, Mr. Stevens.
Judge, we have no formal pretrial matters on behalf of the defense.
All right, are you available on April 15th for docket call?
Let me look. April 15. Judge, I'm all over the place that day. I'm in Kaufman, Henderson County that morning and after.
What about April 13th?
Yes, sir. That'll work.
All right, we'll set Ms. Smith for docket call on April 13th. And Ms. Smith, you'll just appear in person again like you have done today. We're going to fill out a notice of resetting form here. When you sign the yellow copy, Ms. Burns, have you seen Ms. Smith regarding her conditions? All right, so once you sign that notice of setting and get that yellow copy, then come over here and see Ms. Burns. She's going to have additional paperwork for you. Mr. Stevens, we're going to put her on conditions of pretrial release. So if she has questions about that for you, she may give you a call. Otherwise, Ms. Burns will give her the information she needs.
All right, Judge, could you ask, I don't know if my client can hear, if she can she hear me?
She can hear you and see you.
Ms. Smith, give me a call in the morning between 9 and 12 at the office. We'll get an appointment set up for you. Okay?
Yes, sir.
She said yes.
Thank you, Judge.
All right, just come over here and see Ms. Burns and you'll be free to go. All right, is that all you have today, Mr. Stevens?
I believe it is, Judge. I have this afternoon docket over at the jail, but call for this morning.
Okay, thank you.
Thank you, Judge. See you this afternoon.
Yes, sir. Is Ms. Dean here? Mary Louise Dean. Miss Thompson, Miss Dean is not here. If you'll wait for me for just a moment, I'm going to check with our bondsman to see if he has any updated information on her. If you don't mind, just like 2 minutes. And will you step out and see if Mr. Nicholas is in the hallway? Have you heard anything else from Miss Dean, Miss Thompson?
No, Your Honor, I have not. She called my office early this morning and said that she couldn't get a ride to here. And that's basically all I've heard.
Okay. I had Miss Taberham step in the hall to see if Mr. Nicholas was out there. All right, Mr. Nicholas doesn't appear to be here anymore, so court will just issue a judgment nisi in Capias in her case. Did you have any announcements in case that she does show up after your release, Ms. Thompson?
Your Honor, she had been extended a new offer to her by Ms. Heisel, and I was going to ask the court for a continuance for one more setting to allow her that time to think about what she wanted to do in the matter. And I had told her since Monday that she did need to appear for today.
What was the offer?
10 months state jail.
And so you communicated that to Miss Dean prior to today's hearing, and then today she's unable to make it to court?
Yes, sir.
Okay. Writing may be on the wall on that one, huh?
Could be.
Could be. All right. Court will I'm gonna wait till noon. If she doesn't make an appearance by noon, court's gonna take a judgment in ISI under advisement until noon. If she doesn't appear by that time, the court will issue judgment in ISI and alias capia. So no need to keep you around, Ms. Thompson. Appreciate your patience.
Yes, sir. Thank you.
You're welcome. Have a good day. All right, Ms. McCreary. All right, this is cause number CR 2347, State versus Melanie Renee McCreary. And your attorney, Mr. Johnson, attempted to file some paperwork yesterday to prevent your having to appear today, but I think there was an issue with the filing with the clerk, and so it didn't get properly filed. Mr. Johnson is currently in Kaufman County, and he's doing a plea over there at this time, and I believe he's either going to try to come here or Zoom here when he gets an opportunity. So just have a seat. You're welcome to go outside, but at some point I'm going to call your case again this morning whenever he's available, and then we'll have a quick announcement, and then we'll get you rescheduled and we'll get you out of here. Okay. So you're welcome to go outside, or if you need whatever, and then, ma'am.
Should I try to contact him?
No, he's been in contact with my coordinator. So he's aware of what's going on. He knows you're here, and he's just taking care of a plea for another client in another county. So as soon as we hear back from him, if you're not in here, we'll find you and let you know. Just kind of stay close. Don't leave. I mean, you can leave the courtroom if you need to go outside. Just don't drive away without us. Okay? All right, court's going to stand in recess until I hear from Mr. Paul Johnson for Ms. McCreary. So State, if you want to leave and want to zoom in from your office when he shows up, I don't know when that's going to be. We can contact you if you want to do that.
That's fine, Judge. Mr. Johnson called our office yesterday.
I think he tried to file a waiver. I think it was rejected, so just didn't get here in time. So, but since she's here, and if he gets here, then I'm just going to go ahead and arraign her on the record rather than messing with a waiver.
Judge, if our presence is necessary, give us a call. If we need to perform a reading, whatever, just let us know.
Okay. Yes, sir. Will do.
Thank you, Judge.
Appreciate you. We need to call Christopher Mata and Mary Dean. And we need to confirm on Mr. Donald Patterson. All right, Ms. McCreary, this is cause number CR 2347, State versus Melanie McCreary, and you are Ms. McCreary, correct? All right, and ma'am, you are represented by your attorney, Mr. Paul Johnson, and I previously informed you that Mr. Johnson was busy in Kaufman County with another client. I'm not sure if he's completed his work there yet. However, he had filed a waiver of arraignment and acknowledgement of pretrial hearing. And I believe that you signed this document. If I hold it up here, you may be able to see it. All right, if I can get that back. Is that your signature there? Okay. Now, there was an error in this document because it had today's date in there as 3/11. So I've marked that out. And what I'm going to do today is ask you, you've already met with Mr. Johnson about your case, correct? And you've reviewed the indictment and you've seen that and you know what you're charged with and that your name's been spelled correctly. Is that right? Okay. So what I'm going to do is I'm going to waive the formal requirements of arraignment and I'm going to reset your case until April 15th. And so you'll come back before the court on that day with Mr. Johnson and hopefully he should be here on that date and we'll send him an email with this date in there. All right. So I'm going to go ahead and accept this. I changed the date to have you reappear on April 15th. Now that you signed that notice of resetting and you have that yellow copy, you're free to go. And you have signed your conditions of pretrial release with Ms. Burns. So stay in contact with your pretrial release officer and your attorney and your bondsman, and you'll be free to go. Okay. Thank you.
Hello?
Yes, Mr. Mata, give me just one moment. All right, Mr. Mata, if you can lower your phone down to where I can see your face. All right, this is cause number CR 2261, State versus Christopher Jean Mata. We were set for arraignment today. Mr. Mata, have you hired the attorney that you told me you were going to hire?
I'm
You're going to say that again. I didn't hear you.
I'm still a little bit short on the money. I'm a single income now. Me and my lady, we split up right before Christmas, man, and pretty much all my bills are on my own now. So, but I got like $967 now. I was gonna sell my car to pay for the lawyer, but I wrecked my car whenever it snowed and iced over. So now I started last night. I started working with a buddy of mine. He cleans driveways and gas stations and stuff, power wash cleaning system. That's why I woke up late. I didn't get home till 5 o'clock in the morning. But that's where I'm at right now. I have $967 for the lawyer. He told me I had to have $1,750, half of it. So I'm close.
He told you you had to have 1750, and 1750 is one half.
Yeah, half of 3,500.
Here's the problem, Mr. Mata. We've been doing this song and dance for quite some time.
Yes, sir.
I can't let you avoid your the state's prosecution of you in this matter because you don't have money to hire the attorney.
Yeah.
And we started this in November, December.
Yes, sir. At that time, I was on a 2-income deal, and she left me right a week before Christmas, and I co-signed for a vehicle for her, and now she's been give it back. Now I'm gonna have to take over the payments in that vehicle too, and it's I've been going through a lot of stuff, man. Just
Well, I understand, but
I've been staying at my mom's house, sleeping on the floor. So it's either give me a place or come with money for a lawyer. So
I understand, but you know, you're looking at up to 2 years in prison on this charge. You understand that, right?
yes, sir.
This is not a misdemeanor case, you know, set it out in county jail type thing. This is day for day prison sentence.
Yes, sir.
Today is the 11th. I'm going to do for you, Mr. Mata, and this will be the absolute last time I reset your case. Absolute last time. I'm going to give you 2 weeks. If you don't have $1,750 to hire Mr. White, perhaps you need to call other lawyers that may charge less. I don't know.
Yeah, he was the cheapest one I found. 35.
Well, now's the time to call on family and do what you got to do. All right, I'm going to give you 2 weeks. All right, I'm going to reset you to March 25th at 9 a.m. And I want you back. I want you to appear in person that day.
Okay.
March 25th at 9 a.m. And if you don't have an attorney with you, Mr. Mata, then you may have to end up representing yourself in this case. And you're going to have to go up against the state's attorneys and be your own attorney. You understand?
Okay.
And that's not advisable. That's not advisable. All right. So I
When I
can't.
first got on this case, I was not court appointed because we had 2 incomes, but that was in.
I understand. Well, when you get here on the 25th, you need to have your attorney with you. All right.
Okay.
Do not come here without an attorney. I want you to have one.
Okay.
Understand?
Yes, sir.
But either way, you need to be here in person. First thing is you got to be here in person. Second thing, you need to have a lawyer. If you got to be here without a lawyer, then you'll have to explain that to me.
Okay.
All right?
Yes, sir.
All right. March 25th, 9 a.m. Be here in person.
March 25th. Okay.
All right. You're free to go. All right, Ms. Heisel, the court did find a new waiver of arraignment filed for Ms. McCreary by Mr. Johnson. It had the incorrect date on it. It had her to appear today. So while she was here, the court went ahead and just modified the waiver of arraignment, and I set pretrial on April 15th.
Got it. Thank you, Judge.
You're welcome. So the only NISI that we are going to call is Miss Mary Dean, and I've got that under advisement till noon.
Sounds good. We'll see you this afternoon, Judge.
And Jeff brought that down.
Oh, and I do have the plea papers now on Cody Woburn for Mr. Wood. So we've got
Okay, great. Thanks, Judge.
Thank you, ma'am. All right, court's going to stand in recess until the 1:30 docket out at the jail. The court will Zoom proceedings on YouTube as usual.